Hi, I'm Megan Baxter, and I'm an attorney at Miller Canfield. If you've made the decision to shut down your company, there are certain steps you're going to have to follow in accordance with the Michigan Business Corporation Act, or BCA, and your organizational documents. Dissolution is the formal and systemic process of closing your company. MCR's made available to you a guide to use as a checklist to dissolve your company in compliance with Michigan law. In this video, I'm going to walk you through that checklist. Are you ready? Here we go. First, your company is going to need permission to dissolve. This starts with the board of directors. The board can vote at a meeting to propose to the shareholders that the company dissolves, or instead of a meeting, through written consent. Then, the shareholders need to approve dissolution, again, by a meeting or written consent. Now that your company has approval to dissolve, it's time to tell the state. Step 2 of the checklist talks about a certificate of dissolution. This is going to have to be filed with LARA. LARA is Michigan's Department of Licensing and Regulatory Affairs. You've likely already dealt with LARA during the formation of your company. Box 3 on the Certificate of Dissolution is where you're going to describe how your company got approval to dissolve. For the rest of this process, it's going to be important to keep in mind the effective date of dissolution. The effective date of dissolution is not the date that you mailed the certificate to LARA. Instead, it's the date LARA received your Certificate of Dissolution. Notice at the top of Form 531, there's a spot for LARA to insert the effective date. You have 2 months from that effective date of dissolution to request a tax clearance certificate from the state of Michigan. You will have to settle up any outstanding tax liabilities or state filings you haven't done yet before the state is going to issue you tax clearance. If your company owes the IRS, this isn't going to affect your ability to dissolve on a state level, but you're definitely going to want to consult with a professional regarding any federal tax filings or tax obligations that you might need to address. Step 4 is the notice of discontinuance. You're going to need to include that effective date of dissolution on this form too. The winding up process, or winding down, is where you're going to collect the company's assets and sell them. You can use the money to pay creditors and other debts. And importantly, shareholders do not get a distribution until creditors have been paid. Even though your company's dissolved, it can still sue and be sued. Step 6 is an optional requirement, but a good idea because it will limit the amount of time that people have to bring a claim against your company after it dissolves. Step 6 can also be used in a strategic way. If your company has little obligations or no money, you might want to forego the cost of sending notice or making a publication that your company is dissolved. If you decide not to take any of the actions in Step 6, a claim can survive against your company for as long as the statute of limitations provides in Michigan, which in some cases can be 6 years. It's important to know that the information in the checklist and this video are intended for educational purposes and not meant to substitute any legal or other professional advice. If you have any specific questions about your situation, you might want to get legal or other professional advice. MCR can provide a list of professionals ready to help you. I hope this video has been helpful, and even if you decide not to dissolve your company on your own, at least you can take the checklist when you have a chat with a professional and you'll know what to expect.